Criminal justice and the rule of law. If you look at the foundation of criminal law, the law has to prescribe an act before it can be regarded as a crime, and it has to have an accompanying punishment. To prescribe means to prohibit. To prescribe, it means to do something. To proscribe means not to do something. To prescribe, your experience with that is common. Your doctor prescribes medicine to you, you're supposed to take it. So you need to know the difference between proscribe and prescribe. Criminal law is divided into substantive procedural law. We spoke about this in an earlier lecture. Again, the substantive law stipulates a type of conduct that's criminal and the punishments to be imposed, and procedural law sets forth the rule that governs the enforcement of substantive law. History of the law goes back to the Sumerian codes with King Hammurabi, the Greeks and Romans, and came up with things like an eye for an eye, tooth for a tooth, multiple retribution. If you are you steal something, you have to pay back more than what you originally stole to make it even. Use law comes from common law, which originated in England and was used originally to determine inheritance. It was also used to settle disputes and deal with deviant persons. Now, civil law, there's two definitions of civil law, so I want to make sure we know these two. The French followed what they called civil law, and it was developed by Napoleon Bonaparte. And we're going to talk about civil law and criminal law for the most part in California is separated. It's separated in two different areas, and we're going to talk about that in depth in a moment. If you look in New Orleans, they still practice some civil law, and in New Orleans, the difference is counties are called parishes instead of counties, where counties, that word came from the English tradition, and the rest of the United States still uses the word counties for subdivisions of states. So, quick review. What's a misdemeanor? What's a felony? A felony, remember, is a crime that is punishable by death, imprisonment in state prison for more than a year, disqualification from holding office or running for office, and or a fine. Where a misdemeanor is only punishment is incarceration in county jail for less than a year and or a fine. Civil law versus criminal law. Here's the definition you're going to need for testing purposes. Criminal law defines an offense against society. The state punishes the violations. Civil law defines relationships between individuals. Wrongdoers pay compensation for the harm they have caused. Now, in this table, what you'll see is to your left, you have civil law, which is also known as tort law, T-O-R-T law. Now, the victim in civil law is the individual, and the punishment is money or sanctions. In other words, compensation to get you back to where you were before the incident occurred, or sanctions. Examples could be that Chrysler has suffered various sanctions in the form of recalls where they've had defective vehicles that have caused deaths, and so they have to recall the vehicle and correct whatever's wrong. That would be a sanction. Now, criminal law, on the other hand, the victim is the people or the state, and punishment is death, imprisonment, removal from office, disqualification from office, or fine, any of those things. Substantive law, there's 7 principles in substantive law. The first is legality, means that there has to be a written law which describes the action that's outlawed, and there has to be a punishment in there. The U.S. Constitution prohibits ex post facto laws. Ex post facto means that you go back in time and charge people for crimes with a given law before that became known as a crime. So, for instance, if we wanted to say that everyone who wears a red shirt and black pants in school is going to be charged a $500 fine, that's illegal now to do that. Well, if you say, okay, we're going to go back 2 months and everybody that wore a red shirt and black pants, we're going to go after them also. That's ex post facto. People have to have a right to be able to understand that something is not allowed and be given the opportunity to follow the law. Second principle is actus reus, and this is the behavior of either a commission or omission where you do something or don't do something. The third thing is causation, and that there has to be a causational relationship between the act and the harm suffered, meaning that you hurt somebody. The harm is number 4, and that basically says that there has to be infliction on legally protected person. In other words, mens rea, guilty state of mind. Mens rea is Latin for guilty state of mind. It's the guilt that's required. It shows that you had intention to commit the act. And the last thing that the law has to have is a punishment. Stipulate in the law what the sanction is going to be for the behavior. Now, an example would be the elements of the crime for burglary. Now, elements of the crime are called corpus delecti. That's Latin for elements of the crime. Responsibility for criminal acts. The key element for establishing responsibility is really that consciousness of guilt. It's the mens rea. Accidents are not crimes because they lack mens rea. An example is if I'm working a construction site and I have a hammer and it's in a belt and I slip and trying to catch my balance, a hammer falls out of my holster, it goes down 4 stories and it hits a hot dog vendor in the head and kills him, that would be an accident. Now, if I'm standing on the edge of the girder looking down at the hot dog guy and I got a box of hammers and I'm dropping them and I'm testing the wind to see, how close I can get to hitting him or hitting him, that shows an intent to cause the damage, and that would not be an accident. Entrapment is an example of a lack of intent to commit a crime where the government induces a citizen to commit a crime. In other words, they trick somebody into these, here, hold this, and the guy holds it for you, and then you say, okay, you're under arrest for possession of stolen property. That would be entrapment. Evaluating responsibility. There are certain exceptions to being charged with a crime. Those include self-defense, where reasonable force is used to help yourself. Duress, where force or fear are used to make someone commit a crime. Immaturity, where, say, a child who's 4 or 5 years old is asked by a crook to go in a doggy door on a house and open the door for the crook. You're not going to hold that child responsible. Or a mistake where a child is coming home through a window on a second story and the parent opens up and shoots at the figure in the window because they're in fear of their life. It turns out to be their child. That would be a mistake. Now the burden of proof is going to be on the defendant in those sorts of situations. Intoxication, normally voluntary intoxication, meaning you go out and you get drunk and then you kill someone. Most of those, you're going to get charged with manslaughter, which is a general intent crime, which says you're responsible for this. If it's a specific intent crime, I'll give you an example. There was a situation one time where there was a restaurant and bar, and some off-duty officers were drinking in the restaurant. One officer got so drunk he picked a fight with another person in the restaurant and basically got beat up by that person. The officer who was beat up and drunk stumbles outside. He's almost in unconsciousness, and he gets his gun. He lays across the hood of his car, and when the victim comes out, he shoots and kills the victim. In that situation, they were able to charge manslaughter, but they did not charge murder because he was so drunk and beaten up, his consciousness was affected, and he couldn't form specific intent. That was a defense. Now, another defense is person's tricked into an intoxicated state. Person goes to a party. They're at the party and somebody has spiked the punch. They drink the punch and go into the kitchen. They go kind of crazy. It's like PCP in there. The person thinks they're seeing aliens and they start stabbing people. That would be a defense because it was involuntary. Insanity rules. You have to know that something is wrong before you can be charged with a criminal offense. So McNaughton rule says that the person doesn't know what they're doing or that it's wrong, that they have a mental defect. Durham rule says the criminal act was caused by the mental illness. Like there was a guy in Oakland who was absolutely crazy, and he was at a gas station and he poured gas on a woman and lit her on fire, claiming that she was a witch. The next area we're going to get into is the historical development of the Bill of Rights. It starts with the people of England who are tired of religious persecution, and they fled to North America to settle in the colonies. Now, the king considered the colonies his possession, and often the colonists were taxed excessively and were generally oppressed. If they objected to his wishes, he would stick them on a slow boat back to England and try them for sedition. Now, sedition was rebellion or treason. And if you said anything negative about the king, that would be one of the punishments would be you'd be accused of sedition and you'd be put to death. So anytime the king wanted to get more money, he basically would raise the taxes on the colonists, and they would pay gold to him for these taxes. And eventually they got tired of this. As time passed, the colonists started to complain, and the king responded by sending in troops. Suspected objectors to the king's rule were often subjected to searches and seizures without justification. And what I want to tell you is the history of the treatment of the English of American colonists affected the writing of the Constitution and laws that we have today, and we'll get to that in a minute. As an extreme result of the actions of the king, the colonists banded together and adopted a resolution declaring their political independence from England. This was called the Declaration of Independence. Now, the thing you have to remember is if you were an objector and the king suspected that you were seditious, he would send troops over. He would put those troops in your house. You'd actually have troops living in your house. They were always following you around. They were always searching your papers and effects to see if they could find evidence of sedition to put you to death. So look out what you wish for, because the colonists won the Revolutionary War, and they sent representatives to Philadelphia in 1786 to try to formulate an acceptable and workable governmental structure. And that is known now as the United States Constitution, which was penned by Thomas Jefferson. But an original draft was penned or written by Benjamin Franklin, which was actually probably a better copy. And the problems with the initial Constitution, it established three separate branches of government: executive, legislative, and judicial branch. But the state representatives felt that there was a vital weakness that still remained in its structure. Now, colonists had just suffered under the king and feared that an elected president could also become as oppressive as the predecessor. They were wondering, who's this president guy? Could he become a dictator? There were two groups that were basically fighting for political control. The Republicans, who believed that the government was for the people, of the people, and that the people should rise up if the government ever becomes corrupt and overturn the government and put people back in place where they were with new elections. The Federalists believe that the government should run the people and the people should do whatever the government says. Now, the problem with that is that means those in political power are kind of like the royalty. So people feared they're not protected from oppression, and they thought that the central government was too strong and powerful. So they met again in 1789, at which time the Bill of Rights was proposed. Now, the Bill of Rights had many of the qualities and characteristics that the first draft from Benjamin Franklin had, including restrictions on powers to Congress. It said that Congress shall make no law representing an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of people to peacefully assemble and to petition the government for redress of grievances. Translation: freedom of religion. And that the government would not take on the establishment of a religion. Freedom of speech or of the press, meaning that radio, television, now the internet, there's freedom of speech carries on to those other sorts of media or ways of people communicating. That you could say negative things about the government, that you can complain, that you can try to get redress, in other words, get permission to sue the government for fair treatment. That was under Amendment 1. The Second Amendment gave the right to bear arms, and it said that each state could have a militia to protect itself. Amendment 3, billeting of soldiers. Remember I said earlier that soldiers would be sent to live in objectors' homes. Here it says no soldier could stay in your home except in time of war, and that you could get paid if they were there, like renting them rooms. So if someone has a house strategic to the protection of a bay, and you have a invading force, hopefully that'll never happen, but they come into San Francisco Bay, and my backyard is where they want to put some big howitzer, or missile launcher, or anti-aircraft, or who knows what, they would pay me to put that equipment in my backyard. Amendment 4, and this has to do a lot with criminal justice, is the right of the people to be secure in their persons and houses and papers and effects against unreasonable search. And that if you're going to search, you have to have a warrant based on probable cause, supported by oath and affirmation, describing the place to be searched and persons and things to be seized. The key to this is, it doesn't say you cannot search. It says that searches must be reasonable, supported by probable cause, and you have to describe what you're looking for, who you're looking for, and where you're going to look for it. Again, remember, this came from, soldiers doing searches on people to see if they were objectors, and trying to deter that from happening in the future. Amendment 5 dealt with criminal proceedings, and here it said that if you were going to have to answer for a capital or a serious crime, that the information had to be presented by indictment of a grand jury, or it had to be a presentment in front of a judge, basically showing that there's reasonable cause to hold you for trial. It also says that you cannot be put in jeopardy twice. In other words, if you're found innocent or guilty on a case, you can't be retried. It also says that you cannot be compelled to testify in any criminal case against yourself, because what had happened was the King of England would have his people torture you to get you to confess to a crime so they could put you to death. Now you could not be forced to testify against yourself, nor could you be deprived of life, liberty, or property without due process of law, meaning that there had to be a process that was followed and that you were protected from that, and that private property could not be taken for public use without you being paid. Amendment 6 dealt with the mode of trial in criminal proceedings, and it said that all people have the right to a speedy and public trial by an impartial jury in the area where they committed the crime, in the location, the district, or state, and that they needed to be informed of the nature and the cause of the accusation, and to be confronted with the witnesses against them, and to have compulsory process for obtaining witnesses in their favor, and have the assistance of counsel for the defense. So here you have right to a speedy trial, right to a jury trial, right to have the information listed for you, what you're being accused of, right to confront and question witnesses, right to have to force witnesses by subpoena to testify in your favor, and the right to have assistance of counsel, an attorney, to work for you to help defend you. Amendment 7, trial by jury. In Amendment 7, it basically said that if the value of the controversy was over $20, that you had to have a right of trial by jury, and that no fact tried by jury should be otherwise re-examined in any court of the United States than according to the rules of common law. What that meant was that there was an appellate court system, and that if you had a problem with the finding of a court, it could go up through the appellate court system through to the United States Supreme Court. We're going to talk about the organizational structure of courts in a minute. Amendment 8 talks about involuntary servitude, and it says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The history behind this is the Walnut Street Jail was between the hotel where the conventioners who were writing the Bill of Rights, from where they stayed to where they actually went to Convention Hall to write the Bill of Rights. And when they walked this walk every morning or every evening, they could hear people being tortured in the Walnut Street Jail, either being whipped or branded or maimed. And as a result of that, the history is that they wrote in that there should be no more cruel and unusual punishments. Also, it was believed that you should be allowed out on bond of some sort. You'd put something up of value for your release to show that you would show up for court. But this allowed you to be on the street to help prepare your own defense, because it was thought that you would be able to defend yourself much better. Amendment 9, certain rights not denied to the people. This amendment basically said, look, we're writing all these new amendments in, but whatever rights you already have are retained by you. We're not taking anything away. We're just giving you extra rights. Amendment 10, state rights. This says that the powers not delegated to the United States by the Constitution were reserved for the states and for them to come up. So here's where we talk about Nevada has gambling and prostitution. California doesn't. Texas, everyone can carry a gun. California doesn't. New York, you can't even have a gun in the state. So, different states are going to have different laws. In certain southern states, on certain days or in certain counties, you cannot have alcohol still. In 1868, the 14th Amendment was adopted, and this basically said that all persons who were citizens born or naturalized in the United States as citizens had the right to life, liberty, or property, and that they can't be deprived, they couldn't be deprived life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the law. This amendment basically said that if you were African American and you were free, number one. Number two, you couldn't be discriminated against, and not just African Americans, but all peoples. You can't be discriminated against. You have the right to the same treatment under due process. You have the right to the same opportunities for education and housing, etc. Definition of due process of law: it means that the accused shall have their day in court with a right to appeal a conviction. It eliminated slavery and also said that the Bill of Rights applies to all states and local law enforcement as well as federal, because there was some argument about, okay, the Bill of Rights only applied to federal laws, and this basically said no, state laws have got to follow it. So if you look at Alabama, the state university had to allow blacks entry into that college as a result of the 14th Amendment. The next thing we're going to talk about is court structure, and courts have changed considerably. If you look at the history of the organizational structure of the courts, it's in the book, but I'm going to just talk about just really quickly what's happened. There's new mandates, and as of the early 2000s, there's been a change in the power of the lower courts for sure. We used to have justice courts, and justice courts actually ended before, it says 2001 on the slide, but I happen to know that it probably ended somewhere in the mid-80s. And these courts represented populations of less than 40,000. And they handled minor civil cases, low-grade misdemeanors. Judges were elected. And if the judge did not have a law degree, they couldn't sentence you to jail, but they could fine you. Vacancies were approved by Board of County Supervisors. Most communities now are bigger. With the population boom in California, they had to really change. Municipal courts, which ended in 2002, were local courts that were, like, for instance, in the Richmond area, you have the Bay Muni Court, which is now Bay Superior Court. We'll talk about that in a minute. But the county's divided into judicial districts by the Board of Supervisors, usually 40,000 population or more. And the municipal courts used to hear certain civil cases and misdemeanors, and the judges were elected. They were the trial courts for misdemeanor crimes. Felony crimes were assigned to Superior Court. They could hear preliminary hearings and hold people to answer and then ship them to Superior Court. Superior Court is authored by the state constitution. It's a general trial court of unlimited jurisdiction. It deals with all cases except those tried in municipal or judicial court. It also acted as an appellate court for municipal and justice courts. And so if you had a misdemeanor case in municipal court and there was a search and seizure issue and you did not like the decision of the judge, you could appeal it to a Superior Court judge who could overrule that decision. The Superior Court also has direct jurisdiction over juveniles, and usually the judges are specially trained, and it's a whole different group of laws that they follow. California District Court of Appeals is in San Francisco. This is one step below the California Supreme Court. We're in Area 1, Northern California. It's authorized under the state constitution. It's designed to relieve the Supreme Court of the heavy load of appellate litigation, and it has jurisdiction on all appeals from Superior Court except for death penalty cases, which go to the Supreme Court of California. California Supreme Court, authorized by state constitution. It's composed of one Chief Justice and 6 associates. There's an odd number of justices on appellate courts, by the way, because you need to have a decision. You can't have a tie. Vacancies are filled by executive appointments subject to confirmation by a commission of qualifications. The governor will submit names and will appoint people approved by the legislature. Duties and jurisdiction. Appeal in cases of equity involving title or possession of real estate, taxation, probate matters, and death penalty cases. They may take cases from District Court of Appeals to itself and automatically accepts appeals on death penalty cases. The U.S. court structure. Now, at the very bottom you have the trial court for federal level, and then followed by U.S. District Federal Court. And their appellate level is the U.S. District Court of Appeals. There's 12 districts. California is in District 9 with a bunch of other states, all pretty much west of the Mississippi. And from there you go to Washington, D.C., the U.S. Supreme Court. California court changes. There has been elimination of municipal court, and the following slide will show you where we're at now. If you look at the very bottom of this slide, you'll see the District Superior Court. It eliminated municipal court, and it handles felony preliminary hearings, small claims to $5,000, large claims to $25,000. It can handle felony cases now too, but every county does kind of their own thing. Above them is the Superior Court of Contra Costa County. It's in Martinez, and it handles felony trials and juvenile cases and civil over $25,000. Now, Superior Courts, the bottom 2 boxes, those are courts that deal with questions of fact. They deal with whether or not the person committed the crime. Are they guilty or innocent? If you look above that, District Court of Appeals, they don't deal with whether or not somebody's guilty or innocent. They deal with, did the court provide due process? Did they violate the person's rights? Or is there evidence that shouldn't have been allowed in? Was it a fair process? And they look at appeals based on either mistakes made by the judge or violation of rights, and they can overturn the case. If they rule that some evidence is going to be left out, they'll overturn the case and they'll send it back down for another trial. So if somebody's found guilty on a case, they can overturn the guilty verdict, send them back down for a new trial. In some cases, if there's, prejudice or just really a big injustice, they'll overturn the case and not allow them to do anything with it, and that's it. Now, above San Francisco, above District 1, which is San Francisco, you'd have the California Supreme Court. Again, they deal with cases that have gone through the District Court of Appeals and they haven't overturned the case. They've upheld it. The defendant still feels that the rights have been violated, so they send it up to the Supreme Court of California. Okay, now looking at federal courts, bottom of the totem pole, U.S. Federal District Court. This is equivalent to the Superior Court in the state level, but this is the dual court system part. This is the federal District Court, which is their criminal trial court for felonies. This is a court that's used by the FBI, DEA, IRS, all these other federal agencies. If you go and you get convicted of a crime and you feel that, again, there's evidence that was allowed in illegally, you would appeal it to the U.S. District Court of Appeals. There's 12 districts, and again, we're in District 9. And then the final stop is a U.S. Supreme Court. So U.S. Federal Court deals with questions of fact. U.S. District Court, U.S. Supreme Court deal with the appeals. The U.S. District Court of Appeals also will take cases from California Supreme Court. So if you're not happy with the California Supreme Court that we dealt with in the last slide, that's not the end of the road for you. You can go to the District Court of Appeals and then finally to the U.S. Supreme Court. The following are your key terms. You should be able to at least speak briefly about each of these that's here and describe or be able to define the different things that are here. That's the end of this lecture.